Ladies and gentlemen, yes, you've been told my name is Eunice, although I'm a prosecution counsel in the office of the DPP. The presentation reads Emily Kamau, DDPP. I will actually make the presentation on her behalf. She's away on other duties. Madam Kamau is the Deputy Director Public Prosecutions and the Head of Economic, International and Emerging Crimes Department. So my presentation basically is on prosecution of corruption and economic crimes. I've been told 10 minutes, 15 minutes. I will try and summarize as much as I can. In summary, this is the outline. It will be talking about the legal framework, what is corruption, definition or our understanding of what corruption is, what economic crimes are, what the mandate of the ODPP or the role of the ODPP is with regard to prosecution of corruption-related crimes. And then I'll list just a few, I will mention a few cases, notable cases, some which are ongoing, some which are concluded, just for a better understanding of the prosecution process and some of the outcomes of some of the cases. And then I will list some of the challenges. I know challenges have been mentioned by the presenters before, my seniors before, but we will breeze through that and then also mention some of the strategies that have been applied in, that we have applied in prosecution of corruption cases and economic crimes. In summary, I'm sure we all know about this. Some of the statutes that govern anti-corruption or prosecution of corruption cases, the main one being the Constitution of Kenya, the Anti-Corruption and Economic Crimes Act, we usually call it ASECA, the Public Officers Ethics Act, Leadership and Integrity Act, the Proceeds of Crime and Money Laundering Act, the Bribery Act and the Penal Code. We even use the Criminal Procedure Code, among others. On a good day, we will go through each one of them and what offenses they talk about and what some of the penalties are. But in summary, this is basically the legislative framework. Now, I don't know, I think most of us have our own understanding of what we would, how we would define corruption. What corruption would be. I don't know whether I should throw just one question at someone to tell us what is your understanding of corruption. The closest person to me.
You're the man. No, this one here. No. Okay.
I will say what Ilado said, and he doesn't want to say so openly. Paul Ilado says corruption is behaving like Nick Mwendo. I don't know how true that is.
Do you want to say more? Okay. I think we all have our understandings and interpretations of what corruption is. But basically, corruption, off the top of my head, I can also say it is illicit gain, you know? Using whatever, hello? Using whatever it is you have, whatever authority or power or to get illicit gain. Now, when we go to the Anti-Corruption and Economic Crimes Act, am I audible? Okay, something has happened. When we go to the Anti-Corruption and Economic Crimes Act, there's actually a definition of what entails anti-corruption. We can find that under Section 2 of the Act. I'll just breeze through. There's bribery, it lists fraud, embezzlement, misappropriation of public funds, abuse of office, breach of trust. All this we can say at the end of the day, it is for illicit gain. And then what are economic crimes? Economic crimes have also been defined under Section 2 of the Anti-Corruption and Economic Crimes Act, and basically involve using dishonesty for the using dishonesty in order to misuse or misappropriate public revenue. So at the end of the day, we are talking about public revenue, which usually is what is being defined under economic crimes when it is illicitly gained. I hope I have made some kind of sense, yes? Now, just to breeze through this, we all know what are some of the effects of corruption. We know it undermines the rule of law and democracy. We lose trust in some offices when you know that they are mad with corruption and irregularities. It affects or impacts socioeconomic development. At the end of the day, we say it affects the healthcare system. You know, the basic needs of the society are affected. When you hear people cannot get drugs, hospitals are not built, schools are not constructed or furnished, and yet somebody else pocketed the funds that should have gone towards that gain. Corruption also, we say, encourages crime. At the end of the day, because of the greed that it involves grabbing and looking for money illicitly or for gain illicitly, encouraging crime, and breaching the security of society. Now, Madam Lillian had taken us through the mandate of Odpp, so I will not go back to that. But basically, the mandate is the same. Now, we just apply this to corruption cases, where we say Article 157 of the Constitution gives the Odpp the power to prosecute all criminal cases. And in this case, this includes corruption and economic crimes investigated by investigative agencies like the ESCC, DCI, KRA, among others. I think we touched on this. The Odpp in carrying out its role has due regard to public interest, administration of justice, and prevention of abuse of the legal process. Now, just a small understanding of how we process some of the inquiry files within our office is, especially, I will talk with regard to the ESCC. ESCC, under Section 11 of the ESCC Act, they are required to investigate and recommend to the DPP the prosecution of any acts of corruption or economic crimes for us to make a decision. And how do they do this? They do this via a report. We call it a lot the Section 35 report. So they're actually mandated under Section 35 of the Anti-Corruption Act to make their recommendations to the DPP using a report. And then once this report comes to the office, the file is allocated to an officer within the office to be able to review or analyze the file and now make the decision to charge that we had earlier been told about. And we had been told, what does decision to charge entail? You look at the sufficiency of the evidence and regard to public interest. At the end of the day, this is just a briefing of what some of the directions that are issued by the DPP. Once the file has been reviewed, if there is sufficient evidence and it meets the evidentiary and threshold and public interest test, then the DPP can direct that the matter or the accused persons be charged in court, so can direct prosecution. When you go through the file and you find that there are gaps here and there that perhaps if the same are filled in, this matter can still be able to proceed for charging, then the file is returned to the investigative agency to be able to conduct further investigations, resubmit the file for further review before another decision is made. There are times when you go through the file, there's criminal liability does not arise, and at the end of the day, we still have the right to be able to make recommendations for administrative action. And in cases where there's really no evidence or no culpability or wrongdoing on the part of any of the people, the suspects, then the DPP can order that the file be closed. Just in summary, other roles, we have roles in appeals. We have roles in appeals where appeals can be made to higher courts. We also have the right to approach another court when dissatisfied for a review or a revision of an order made by the court. Madam Lillian had also talked about plea bargains. We also, as the Odpp, have a role to play in plea bargaining, as well as diversion that had also earlier been spoken about. Now I'll take us through, I don't know how many minutes I have. I'll just take us through in brief some cases that are ongoing and some that have been concluded. For example, this one has been concluded, the Youth Enterprise Development Fund. It involved a fraudulent transfer of 180 million shillings thereabout and some figures belonging to the Youth Enterprise Fund. At the end of the day, the accused person was fined 720 million shillings or in default to serve 25 years in prison for defrauding the youth fund. This is another case, however, this one is ongoing, so I will just give us a status. I think the matter is proceeding, will be proceeding for hearing. I think this month, if I'm not wrong. The Lake Basin Development Authority is also another high-profile matter. The matter is ongoing. It's currently in court, although there's a stay from the Court of Appeal, but the accused persons have taken plea. There is this is a concluded case, the one involving the MP for Sirisia, John Koi Waluke. I think this one also really made it to the media. The one where the two accused persons were charged, were fined 727 million shillings and 707 million shillings respectively, and in default 10 years imprisonment. I know the accused persons or the convicted persons appealed to the High Court, and the matter is currently pending before the High Court for hearing of the appeal. This is also another high-profile ongoing case where the Deputy Auditor General was charged before court. I know some of these cases I'm mentioning were affected by the COVID-19, you know, because of the numbers of people in court, the number of accused persons and the small courts, the matters were not able to proceed for hearing, and as we had to abide by the Ministry of Health guidelines for spacing. So some of these are those matters that were affected by the COVID-19 pandemic, as well as the NYS2 scandal. The matter is also ongoing in court. They currently have dates to proceed. It was also affected by the COVID-19, and because of the large numbers, it was not possible to hold open court hearings. Mr. Mule, our Deputy Director, had given us some of the challenges. Okay, I think I will breeze through. He talked about the numerous applications. I just mentioned some of the high-profile cases, like the Mike Sonko case, the LBDA case, the Engineer Kamau case, the applications that are being made that you would want to proceed with the hearing, but still have to address the applications first. And then in certain cases, the matter is stayed. When you say the matter is stayed, you have to halt the matter in the trial court until hearing and determination, usually by a higher court. So these are some of the things that have slowed down some of the cases. An issue with some of these matters is also witnesses reluctant to testify against their colleagues or their peers or even their seniors for obvious reasons. And then witness fatigue, where you have witnesses coming to court and perhaps because of the complexity of the case, they testify for 3, 4, 5 days, and it's pushed to another, week. The witnesses actually get fatigued. Complexity of corruption cases. I think this goes without saying how complex the corruption cases are. You require numerous witnesses to come and prove a lot of some of the complexities of the cases. They have voluminous documentation. Some of them involve money that has crossed borders, so involves MLAs and extradition requirements. Then also the issue of oral evidence. You know, sometimes there are some jurisdictions where you're allowed to just present a document or a report, but in our jurisdiction, you actually have to come and testify on the document and produce this document. I'm not saying that it's a challenge per se, but yes, there's room for us to review this as in law reforms. Then I've talked about the MLA and extradition that slows down some of the cases. I think they've been mentioned, the Aror, the Kimwarer, the other case that Lillian had spoken about. And then the obvious one is the politicization of corruption cases, where the focus is diverted from the offense committed, and then we turn it into a political topic. So now it is our tribe, our people, and you mobilize the masses against the main focus. Now, what the ODPP, I feel like I've been running out of breath to keep my 2 minutes. Now, what the ODPP is doing, some of the strategies that we have in place, I will just list a few. They've been listed also by my colleagues before us, is the enhancement of a working relationship between ODPP and other investigative agencies and stakeholders in the criminal justice system. Here we are talking about the DCI, the KRA, where we hold joint trainings, we hold joint meetings, regular meetings, basically just to make sure we are on the right track. By the time we take these matters to court, they should be seamless as much as is practicably possible. There is also the issue, we have applied team-based prosecution, where now teams are appointed to be able to review, analyze, and prosecute files in court. You know, some of the files are so bulky that when you have one prosecutor in court, it can result in fatigue. Then we assist each other, we brainstorm. By the time we are going to court as a team, you know, we are ready to face sometimes over 20 advocates on the other side. So that works in our favor. I think we had also been told about prosecution-guided investigations, which is provided for in the ODPP Act. I've spoken about interagency collaboration and the issue of joint trainings, capacity building, and then also the issue of follow the money approach. I think I spoke about how sometimes the money, you know the money reached wherever it reached, but you need to find a link that gets you there so that you have your evidence. So some of the strategies we have is once you know where the money reached, you can be able to create a link. And by creating a link, you'll be able to find the people culpable, criminal culpability, and be able to get now the suspects that you can charge in court and understand actually the conspiracy that resulted in that corruption. And then the use of experts, for example, fraud experts, audit experts, and procurement experts. Like I'd said, because of the complexity of some of these matters, it is best to get an expert who will come and lay a basis and help us best understand. In fact, it helps both the investigators, the prosecutors, and even the court to be able to understand what some of these transactions are. Some financial transactions are so complex that you require that once you get this expert to, for example, give a report or assist in investigations, how you even prosecute your case is much better. The magistrate understands better, and you can be able to get your conviction at the end of the day. I've spoken about consultative meetings. I think Madam Lillian had also talked about automation of case management system in order to ensure accurate data capture. That works in our favor. I think I have covered most of them. And the role that the ODPP plays, like in the NCAJ, and in also the law reforms, contributions to policy and legislative reforms in the fight against corruption. Yes, I have tried to keep within the time. I hope we have understood as much as possible. I will let my colleague come and take over.
Thank you, Eunice. Makofi kwa Eunice. Editors Guild, hoye! Editors Guild, hoye! Space ya maji mjaeka, Editors Guild, hoye! Haya, ameweza majaweza? Ameweza majaweza? Haya, that's the next generation of ODPP. Now we'll introduce Mark Barassa. She did 20 minutes, so she did very well.
Thank you.
Mark, 10 minutes, nitakupatia kidogo ya maji.
Honorable DPP, sir, heads of department, distinguished ladies and gentlemen, good afternoon all. Good afternoon again. Hamjambo. Mbona mnakaa ni kama usingizi? Kiswahili changu sio kizuri kama cha Bwana Hassan. Huko ninakotoka huwa tunasema Warieng ni aje. Pengine ule anaelewa tu ni Bwana Okinyi. Ndiye anaweza jua hiyo lugha kidogo. Bwana Okinyi anasema haelewi. Sawa. Good afternoon again. Thank you very much. My name is Mark Barassa. I have been asked to make a presentation on the role of the ODPP in election preparedness. That's my name as shown on the slide. The aim of this presentation is to outline the role of ODPP in electoral justice and preparedness for Kenya's 2022 general election. Elections and national security. Under Article 238, the national security is the protection against internal and external threats to Kenya's territorial integrity, sovereignty, its people, their rights, freedoms, property, peace, stability, and prosperity. So national security is people-centric. It's not just state-centric. When we talk about national security, we are not just talking about territorial integrity and government. We are also talking about people. We are also talking about rights. We are talking about freedoms. We are talking about peace. We are talking about values such as democracy and election rights, which we also need to protect just the way we protect our territory. And to protect those national interests, we don't need the military instruments of national power. We also need law enforcement agencies involved in election management, such as the ODPP. So that is the link between elections and national security. On election preparedness, we remember the words of a very famous American security strategist, Henry Kissinger. He said that if you don't know where you are going, any road, or every road will lead you nowhere. So you must know where you are going. You scan your situational analysis. You scan your security analysis. So the international and regional security environment is already vulnerable following the COVID pandemic, insurgency, divisive elections. In Uganda, you had a lot of complaints. In Tanzania, the same. In Burundi, the opposition actually, they refused to acknowledge the results. So those are the strategic issues regionally. Here in Kenya, it's a very important geostrategic location. And these elections, the coming elections in 2022 are very important, not just for Kenya, but for the entire region. We have so many multinational organizations which are resident here in Kenya, and therefore the regional environment in the Horn of Africa and the larger Great Lakes region are looking towards Kenya for peace and stability in the region. So election security in Kenya in the forthcoming general election is very important, not just for Kenya, but for the entire region. There is a lot of insurgency in Ethiopia, some terrorism attacks. So we have to ensure, as bodies charged with election management, that peace and stability, not just for Kenya, but for the entire region. We are a multi-ethnic country with many ethnic communities, and this predisposes us to a lot of conflicts over resources. There is heightened political activity. We have issues of evidence collection, which we discussed earlier about journalists coming across evidence and chain of custody. Where do they take that evidence when they come across it? The judicial framework is also an issue because election offenses, the cases take very long in court sometimes, and it becomes a challenge for us. We lack ready pool of experts. For example, in hate speech, you need an anthropologist to come and give the context within which that hate speech was uttered. You also need IT experts because issues of cybercrime, some elections are committed online, so you need technological experts and all that. So these are the issues that we are dealing with. The role of ODPP as regards election security, the DPP independently directs investigations for election offenses. The DPP has established a hate speech and electoral justice division. The DPP is training personnel that is ongoing. We are engaged in interagency collaboration with stakeholders, including the media. There is public and stakeholder sensitization. The DPP has also formulated key guidelines We are ensuring that the decision to charge is fair for just and criminal for fair and just criminal justice. Also, regarding preparedness for the coming general election, we have offices in all the 47 counties and sub-counties, so that enhances access to justice. The DPP recently launched a charter of excellence showing our strategic commitments to guide the ODPP operations from 2020 to 2023. We are engaged in inter-agency collaboration. Those are our mandates under the Constitution. We direct complaints. We peruse investigation files for election offenses when they come. We attend court to prosecute offenses. We are also engaged in review of legislation. Also, we advise government agencies. There are other emerging issues. For example, we do not claim that we have investigated and prosecuted all election offenses. We have a challenge in the Election Offences Act. Under Section 21, 22, you are supposed to prosecute those offenses within a year and not more than 2 years. So we are engaged in legislation review. There are some cases which we agree are still pending. We have committees which are looking into it. Also, there have been complaints about misuse of state resources, including use of force by the state agencies. Funding is an issue. We have structural inequalities in the society, militia groups, extrajudicial killings. These are issues that we are addressing. Mutual legal assistance and cross-border access, what our chief of staff was saying earlier, Madam Lilian Obuo, getting evidence and investigation of offenses which are committed overseas. And then new legislations and institutions. The legislations relating to election offenses are less than 6 years old. So they are still new, and we are still implementing them. Some institutions are also new, fairly new. Who are our major stakeholders? The IEBC, of course, when it comes to election security and election management, the IEBC is a major stakeholder. The National Security Council is a major stakeholder, the judiciary, the National Police Service, Kenya National Commission of Human Rights, IPOA, all those investigation agencies. NCIC, when it comes to hate speech, they are a very major stakeholder. Multilateral institutions, development partners like United Nations, those are very important stakeholders in election security. Civil society and the media, very important stakeholders. On interagency collaboration, we are collaborating with many agencies, including the National Police Service. Recently, we assisted them to come up with a manual for police commanders. This will help them to guide their operations during elections in investigation of election-related crimes and hate speech. So we helped them to develop, we gave them sample charge sheets to guide them when they are investigating election offenses, so that they can know what ingredients to look for when they are investigating, so that when they bring the files to us, it becomes easier for the prosecution counsel to make a decision to charge. So as a division within the Office of the Director of Public Prosecution, under the Offenses Against the Person Division, we have attended one workshop organized by UNOHS, United Nations Office of the High Commissioner for Human Rights, and Kenya National Commission for Human Rights. We have attended a workshop on safeguarding civic space. We have attended 2 interagency workshops on election security with IEBC and other agencies. We have attended 2 interagency workshops on hate speech with the National Cohesion and Integration Commission. We have attended 2 social media stakeholder interviews on ODPP Cafe. We normally invite stakeholders to come and discuss. We have also attended 1 interagency workshop with the German NGO known as Konrad Adenauer. We are also engaged in several workshops with the National Police Service to help them develop their manual for police commanders. So this is what we were able to do in the first quarter, beginning July to July, August, September to October. In conclusion, under the leadership of the Director of Public Prosecution, the ODPP is dedicated to upholding the rule of law, protection of the democratic will of the people, and civil rights of all Kenyans as part of election security. This is not a favor, but a duty owed to Kenyans, not just by Odpp or IEBC, but by all election management bodies and duty bearers. And we will do this through the whole of society approach that brings together the media and the biggest stakeholders, that is the people of the Republic of Kenya. Thank you very much for listening to me.
Makofi kwa Mark Barassa. Actually, he stuck to the minutes, to the, I think even did less. He did less. To introduce the next panelist or the next presenter is our youngest member of the team, Leila Dyer.
Hello, everyone. Seeing as I'm the last presenter, I'm sure some of you are either a bit bored or a bit tired. So I am going to try and make this as engaging and short as possible. But also on the flip side, if I'm boring, that means you'll have less questions. So we'll see which way this goes. Crime mapping in the Office of the Director of Public Prosecutions towards the future. So before I get into crime mapping in the office itself, I kind of want to give you a background. So what would you describe as mapping? Mapping in itself can be referred to as a visualization tool that is used to display raw geographic data and output from analysis. When it comes to the criminal justice sector, it's used as a means to analyze the relationship between place and crime. This is because, according to environmental criminology theory, place is really important in explaining why crime occurs. So for example, if it's a poor area, people are more likely to steal. So what is the history of crime mapping in general? Crime mapping began in the early 19th century in Britain and France. So in France, it was used to determine where more property crimes were happening. And after a while, they were able to see that in places where more property crimes were happening and where places where less property crimes were happening, this remained constant, meaning that mapping of crime was really important. In 1924, crime mapping then moved to Chicago to look at juvenile delinquency and see which areas were more affected by it. In the late 19th century, crime mapping began to take more effect in the US to describe what was happening in the different states. And in the late 1960s and early 1970s, began the use of geographic information software, which is what is used today in crime mapping. So geographic information systems, it's basically just on a computer, you can layer data onto real-life geographic units like longitudes and latitudes, and you're able to manipulate them so you can display this data according to a place. So what are some of the advantages of crime mapping? Well, basically, crime mapping provides you with an understanding of what drives criminal activity and where this criminal activity is happening. It also lets you understand where this criminal activity may continue to develop. It informs resource allocation in regards to what are the hotspot areas that crime is happening in. And if you improve resource allocation, you get to improve the performance of criminal justice actors. Well, despite all of these benefits, crime mapping isn't really used in Kenya as much as it should be used. According to a 2017 countrywide needs assessment commissioned by the Government of Kenya, the United Development Programme, and UK Aid, they found out that it's not really used, and we're mostly still using Excel sheets, which doesn't really give you what a map of data does. So let's get to crime mapping within the ODPP. So as you all know, recently we've expanded to all the 9 regions and 47 counties within Kenya, which has brought access to justice closer to the people. We've also created more specialized divisions, such as the hate speech division, sexual and gender-based division, and counter-terrorism division. All of this is really good, but we need to make it better. So crime mapping can help us determine what are the different predominant crimes in the different counties, which counties have the highest rate of crime, and which counties have the highest rate of crimes that require specialization, such as SGBV, terrorism, wildlife. This information can help us improve that access to justice that we've already decentralized by allowing us to allocate personnel according to where the highest rate of crime is, which means more number of cases in courts, helping us to determine which prosecutors in which counties should go for what trainings. And as we're trying to go to restorative justice and go to the community level, it allows us to determine our community dialogues a lot better and the topics that we should be talking about. So at the moment, our data collection methods is done on a quarterly basis from each county, which is then put onto a master spreadsheet. Going through this spreadsheet is kind of difficult to realize, to determine what exactly are the predominant crimes in each county. It's pretty neat for presenting data such as this, and data such as this, which is from our last financial year. But the issue is you can't actually tell which counties are have the highest number of rape cases or defilement. And so that's where crime mapping comes in. It allows us to establish exactly where the predominant crimes are happening. So here we have a heat map which shows which counties have the most amount of crime, which makes it a lot easier to determine where our personnel should go. So at the moment we're using Qgis, which is an open source software, so it's still a bit clunky. But this is essentially a map of the different counties. And when you go further into it, it allows you then to break it down like that. So you're able to have a pie chart and see for each county what are the predominant crimes. And data can be very hard to digest. But when you break it down like this, it makes it a lot easier to actually see what you're dealing with. So our main goal is to improve on our crime mapping and make it more accessible, but also the benefits of using crime mapping is that it will also allow us to start forecasting. And we'll be able to go through the years and see whether crime is increasing or decreasing, and in which areas. Thank you.
Well done, Leila. For wale wanauliza, Leila anatoka hapa tu Kiambu, Nakuru. Msistuke sana. Okay, so we are in the Q&A session. And who wants to go first?
Good afternoon, everyone. My question goes to Eunice. You talked about COVID-19 having halted the cases because you cannot, the accused are too many and you cannot hold open court sessions. So I'm just wondering, COVID is going to be with us for a while. We actually don't know when, but all indications are that it's going to be here for some years. So then, what is the way forward for those cases? Will they be in abeyance indefinitely, or what's going to happen? The second question, still to Eunice, is on witness fatigue. I'm just wondering whether you have, your office, the Odpp, has sought to find out why we have this witness fatigue. What are the reasons we have that? And in those cases where you have witnesses dropping out, what is the way forward for cases? And what can be done to make sure that you have at least, a success rate in prosecuting those cases? Thank you.
Okay, Okari?
Thank you. My question is to Ms. Leila on our presentation. I just wanted to know the research that you're doing and the figures you're coming up with, are they based on reported cases in police stations in those different areas? And two, is this information accessible to journalists or to the public, or is it just within the consumption of the ODPP's office? Thank you.
Asante. Mimi nina maswali kwa Kiswahili tu kwa sababu nimegundua kwamba Wakenya mna tabia mbaya sana ya kupuuza Kiswahili hata mkiwa mko pwani. Tunafanya warsha pwani lakini Kiingereza kimezidi we. Mimi nina swali kwa huyu bwana anaitwa Bwana Barassa. Ulitaja katika uwasilisho wako kwamba ODPP has established something about hate speech. Sasa nilikuwa ninauliza kwamba sijui kama mmepata kuna udhaifu katika ile taasisi ambayo imetengewa shughuli hiyo ya kutambua semi za chuki katika Jamhuri ya Kenya wakati wa uchaguzi, inaitwa NCIC. Manake Kenya huwa kuna mkanganyiko wa majukumu katika baadhi ya matawi ya serikali. Kwa mfano katika nyanja ya elimu huwa tuko na CUE, Commission for University Education. Then there's another one also called KNQA. Also wanashughulikia masuala ya ubora wa kozi. So you wonder who is doing what. So kwa hivyo hapa NCIC na ODPP mmeelewana, mna mkataba kuhusiana na semi za chuki, ama ni nani anafanya nini wapi? Alafu la mwisho kwake Leila, kwenye uwasilishi wako umezungumzia crime hotspots. Nani? Hapana, nimesema Leila. Hapana, nimesema Leila. Leila, in your presentation, what's happening? You talked of crime. Yours was about crime mapping. Nimeona too so many dots. I don't know. You should have really come out clearly and told the journalists kwamba the specific areas are this and this what we should be focusing on, so that I should know that where exactly are you really pointing out to be a crime hotspot. Thank you.
Mine, just an addition to that, as you come up to respond to that, because already there are leaders in this country who have made what I would describe as inflammatory statements, hate speech for that matter, and they are there, the likes of Sudi, the likes of Gerard Gay, who is in court. So as you come up, what exactly are you doing to the likes of Sudi ambao hawajashtakiwa kwa hate speech? Because it's there. Ama umengojea kilipuke kwanza? Hai.
Can I ask Senior Mark Barassa to start from the session? The question, the answer.
Nashukuru sana kwa hayo maswali. Nitaanza na swali la kwanza ambalo limeelekezwa kwangu, na swali liliulizwa kwamba ni kwa sababu gani ni kwa sababu gani ofisi ya mkurugenzi wa mashtaka ya umma ina kitengo ambacho kinahusika na masuala ya hate speech na election justice. Na is it because there are gaps in the bodies which are charged with the hate speech? Kisheria, the National Cohesion and Integration Commission is charged with managing issues of hate speech. Lakini tunajua kwamba there are so many offenses under the law. There are offenses relating to economic crimes, offenses relating to elections, offenses relating to agriculture, crops, livestock. Ili kazi yetu iweze kuwa rahisi, kuna ile kitu inaitwa division of labor. Sio kwamba tunaingilia kazi ya watu wengine kisheria ambayo sheria inawapatia jukumu la kufanya, lakini it's just to ensure that we are efficient in our work, so that there is a dedicated division. NCAC wakileta hiyo file ya hate speech, kuna watu wametengwa, wamewekwa pale kudeal na hiyo file. IEBC wakileta file ya elections, kuna division iko pale to handle such files, just for efficiency. It's not like we are now discharging the mandate of the NCIC. We work together collaboratively with them.
I think, Barassa, you also need to explain. NCIC investigates. They prepare the file and bring it. We are the ones who prosecute. So, in order for us to be able to specialize, we have different departments. Just like we have a department that deals with anti-corruption, we also have a department that deals with election violence and also hate speech. So they work hand in hand with NCIC. We don't investigate, we prosecute. And for us to be able to fast track, then we have this division that works with the NCIC, and it's mandated, and it specializes in prosecuting those crimes.
Thank you very much, sir, for that very splendid explanation. Na swali la pili ambalo liliulizwa, someone asked about the inflammatory statements. What are we doing about it? The likes of Oscar Sudi. Just for your information, and as you rightly observed, we have cases in court involving Oscar Kipchumba Sudi, Republic versus Joanna Ngeno, Republic versus Cherargei, Republic versus Ledama Olekina, and others. These are cases that are ongoing in court. We may not want to go deeper into them because of sub judice issues. So if a file comes that has been investigated and there is sufficient evidence, as our leader said, be assured mtu atachajiwa. Evidentiary and public interest considerations is what we look for. If there is evidence, ataekwa kotini. So nobody has a free ticket to engage in hate speech. Investigative bodies should do their work and investigate. Wakituletea file, the DPP will look at the file, review it before deciding whether to charge. So I hope with that we have been able to address the questions. Thank you.
Eunice?
So actually, hearings were proceeding virtually. The good thing about I don't know that to say it's a good thing, some of economic crimes is most if not all of the accused persons are represented, and they're usually represented by people who are tech savvy. So we were able to proceed with these matters virtually, and accused persons were all present in court. Right now, I know the courts, at least the anti-corruption courts, have made provision. There's space, open space outside at the car park and various other parts of the court premises. So that's how the matters are able to proceed. So for now, all the matters that I had mentioned have hearing dates and are supposed to proceed. I think you also asked about witness fatigue. Now, there are a few strategies I can say we have tried to put in place. For example, I'll give the example of like the NYS case, because there are 3 cases usually, and they share witnesses. So the issue was that when one witness testifies in this court, when she's done as PW1, she comes to this other court as PW2. By the time she's coming to the 3rd court as PW3, you can imagine the fatigue. So we alternate them. So the first cluster will start with another witness, and the other cluster will start with another, and basically play around with that, as well as also taking breaks. I know it's supposed to be day to day, but we take breaks in between. So you probably testify Monday, Tuesday, Wednesday, and then take a break until, the next week. We're all human, we get tired. And then with the pre-trials that we conduct, you're able to now limit their testimonies to just what it is that can be able to, that the court, that will assist the court to come with a just finding. With regard to those that drop out for various reasons, say, for example, intimidation or threats, our office, I know, works with the DCI directly with the Witness Protection Agency to be able to give them protection and assist them to be able to testify before court. Then there's also another strategy that, which at least the court has allowed us to do, is where that you are allowed to mark documents in court using inventories. You know, some witnesses would come and testify and mark over 600 documents. So that also is to respond to your question on witness fatigue. So some courts have allowed, instead of marking each and every document, you mark an inventory with a list of documents. So you see, you've killed, you know, having to go through documents and flip pages of things like payment vouchers, which have annexures and all that. So I think those are just some of the remedies that we have adopted.
Maybe in addition, the issue of witnesses, first of all, we've also been accused of having too many witnesses and also too many accused persons in the charge sheet. But one thing that we have done is, for example, with the issue of individuals that we have charged, we have been trying to negotiate with some of them to enter into plea bargaining agreements. And when most of these people are individuals who are directly involved, it allows us then to reduce the number of other witnesses that we might have had to use if those people remained in the charge sheet. Secondly, what we've done is, as ODPP, we've come up with what we're calling the witness facilitation program. And we've set up our own funding system to help with the crucial witnesses, to ensure that they're available. One of the biggest problem we had was, you know, you were expected to reimburse the witnesses when they come to court. And there was a pull and shove between the judiciary and the DCI, the police officers. And most of the time this really discouraged the witnesses from coming, because they will come all the way and then you hear it's a mention or something has cropped up. They are not able to come up and give the evidence that, that they were required. So we have tried to see how best to cover that. And we've also tried to ensure, together with the judiciary, under the NCAJ, with the help of the Chief Justice, we have what you call the CUCs, which are the court users committees, where we sit down with the magistrates and even the defense and all the individuals who use the court and agree on how best we can reduce some of these incidences that bring about fatigue within the witnesses. So we are doing a we have multiple approaches to trying to solve this issue of witness fatigue. On the issue of COVID-19, as ODPP, I think we've become, or we've tried to become as resilient as possible. As ODPP, we are now able to attend all virtual courts. We have invested heavily in IT and giving all prosecutors the means to be able to appear before court virtually, so that we have no excuse. Of course, the first 1 year, it was very difficult, but we managed to overcome that challenge. In fact, I think a lot of things that we did was, as ODPP, was innovative, and we now had other departments of government coming to see what we've done and borrowing a leaf from us. Moving forward, you will see you'll see a hybrid, whereby in certain instances we have the cases being heard virtually, and in other cases where we appear in an environment that is COVID compliant in terms of the protocols. Thank you.
So as we prepare for the next session of round of questions, Leila needs to demonstrate and answer her portion of the questions.
Sorry. So in terms of your question, so the data that we use is collected from the counties on a quarterly basis, and that data is the cases that we decide to charge. So it's not data from the police, it's our ODPP data on cases that we decide to charge. In regards to accessibility, we are working on creating a website that can be interactive and can allow you as the public to gain this information. But at the moment, we're still ensuring that before we do this, that our data is as valid as possible. In regards to the heat map, I should have explained better. So where it's a darker red means that there's a higher incidence of crime compared to where it is lighter. So that's in comparison to other areas will be the darker red, if that makes sense. And yeah, just so you can kind of stare. So it's all just like pie charts, and on the side is a key. So you can easily pick out that the biggest like issue in like Mandara is traffic related, or in Turkana it's assaults, in Marsabit it's assaults as well. Samburu like to keep their crime more equal, so yeah. Any questions?
How accurate is it in terms of the reporting? And then I'm just saying, like, there are some places where you have terrorism. How can you describe that that kind of crime? Like, to what level, such incidents? What kind of terrorism is that? Sorry to ask. I don't know how to explain it better. But I'm just wondering, because it seems like.
Okay, so basically, so we have a prosecution case diary, and within the prosecution case diary, so terrorism will be broken down into, like, having an explosive weapon, aiding someone who has an explosive weapon. Like, there's multiple categories that it's broken down into, but it's like you can't put all of that down. Like, all of these categories, like, you wouldn't be able to like showcase it on a map. Then it just gets too complicated. So it's easier to just, in our data, it is broken down like that. But when it comes to mapping, because there's already so many categories, the pie chart will just get too complicated and will detract from trying to make it simpler and easy to access. But the aim is to be able to click into that category and then be able to see how it's broken down in terms of the individual numbers. In terms of how valid it is, that's the thing with data, is it's like it can only be so valid. Like, there will always be a few discrepancies, but we try to get it as accurate as is possible. So we've been having multiple validation exercises to ensure that.
Yeah, I think what Leila is saying, I don't know if you've understood. If you want the specifics of, say, money laundering, what are the cases that happen, then of course you can click and get that, the detail, the inner details of what kind of crimes we can see is occurring there. But we can't capture all that here. Otherwise it will be a very heavy document. So when it says, as you picked terrorism, if you click on that, then it will be able to give you the specifics in terms of what kind of terrorism incidents are occurring in that area. Then really the purpose of this is to help us as ODPP to be able to make the right decisions in terms of allocation of resources, in terms of specialization, in terms of training, in terms of even human resource in the different areas, and the kind of equipment and capital that is needed to be invested there. of course, this is something then that can, value can be added to it in terms of the kind of information that the police would have and at the end the judiciary. Then it will be able to really allow us as a whole of government to make the appropriate policies towards discharging our mandates and ensuring that access to justice is there for everyone. Now, the other way that this data will be available apart from the website is, of course, it will help us in preparing our annual reports to Parliament and to the public. And this will really help us to demonstrate to Kenyans what is really happening on the ground in terms of the kind of cases then that we are able to prosecute and the kind of convictions that we are producing. In addition, the kind of information that we are getting, as she said, is based on Odpp and the cases that we have and the cases that we are prosecuting in court. So this might not necessarily be reflective of all the cases that are happening in that area, but I can assure you it is reflective of what is on the ground.
Okay, thank you. My first question goes to Eunice. And when you started, you talked about a number of laws that are used to fight corruption. And my main concern was that why should we have around 6 laws on corruption when we can actually collapse them to be able to address the issue of mandate overlap? Because you find that there are those that when they're investigating one case, you find EACC investigating the same, DCI is doing the same, Asset Recovery Unit is doing the same, and maybe KRA is doing the same. Is it not a concern to you that maybe you need to push some proposals to have these laws collapse into one? And then to Barassa, you talked about the hate speech and how you're working with the various stakeholders. Are you aware that NCIC has come up with proposals to amend the NCIC Act? And one of the proposals is to seek prosecutorial powers to prosecute hate mongers, because they are saying currently, if you look at the law, no matter how many people they take to court and work with the ODPP's office, they have not been able to secure any successful prosecution. So maybe how...
Maliza.
Sasa hata umenichanganya. And then there was also the issue of interagency collaboration, and you said that ODPP has helped the police to develop a manual for police commanders coming up with a sample charge sheet. Is this one different from the charge sheet you're talking about that will have the format for charging cases? Is it that this is different because it's for elections? And then finally is on Leila on the crime mapping. I think that is a very good tool for us. I saw you are trying to compare and contrast years from the 2000 to up to now. Maybe you need to look and contrast for us so that when the media gets this data, you are able to look at which years we had the high number of cases and exactly which ones. Is it money laundering? Is it terrorism? Is it murders? So that at least we can classify and see where we are. Thank you.
Okay, I think I'll start with that interesting one that you asked. You know, I always don't understand why individuals always want to get prosecution powers. We've been here with you. We've never asked for investigative powers. Never. But if somebody wants to attempt to go to Parliament to get those powers, they should still understand constitutionally and within the CPC, they will still have to be under the purview and supervision of the ODPP. and I can choose to say, fine, you have the powers, utangoja kwanza. You have to be able to demonstrate you have the right prosecutors in place. They have to go through training. They have to be at par with Odpp prosecutors. It is simple. We don't mind. They can have them, but they will have to know that there are laws and regulations, and that the state powers of prosecution lies with the Odpp. But really, NCIC should first work on getting the capacity and ability to investigate those crimes, and then think about now whether they can get prosecution powers. They have too much to chew, and I don't know why they are jumping to other people's mandates. For us, of course, it will go to POSIT, and we will ask them to first try and get the funding that is required for them to be able to get those people and to investigate and bring files to us that has evidence. It's as simple as that. So, Mr. Barassa, unaweza jibu hizo zingine.
Excuse me, do you mind, Mr. Mulle wanted to just add on a few things?